we're going to, right. So we are going to go over a very basic, very short, 2-page performance agreement. And I did this on purpose. So first of all, I'm a big fan of clear and simple contracts. So we were talking about contracts earlier, about an hour ago. And I said at that time, and I'll reiterate, what's your name? Scott, to ride your coattails, to ride Scott's coattails in his example. A really good contract reflects an understanding between two parties, two or more parties, right? And, Scott referred earlier to sitting down with someone and going through the line items that are in the contract so that everyone knows what to expect, what they are signing up to do, what their duties are. And that is a very important process to undertake. Even if both parties are represented by different attorneys, it's important to do ahead of time, because a contract, again, should always reflect your existing arrangement, what works for you. And it shouldn't be the opposite. You shouldn't have a situation where your contract tells you what to do. Your contract should demonstrate in writing what you're doing, okay? Or what you're planning to do. It should not be the driver. You should be the driver. So we're going to go over like a basic agreement for the commission of a performance by a musician. And when we talk about a musician in this context of this agreement, it can mean a band, it can mean like a trio, it can mean a solo artist. So a musician doesn't just mean a musician. It means whoever the performance act is, okay? It's a term, again, what I've alluded to prior, it's a legal term of art. So anytime you see in a contract here where it says musician with quotations around it, that means it's specifically makes reference to whatever's in that space preceding it. So it could be Randy MC, which is a great name, by the way. I just put that together when I said it, it required me saying it out loud. Or it could be, the Rolling Stones, okay, and still have the same effect. So what I want you all to know, what I want you to be able to do when you go through an agreement is to identify and understand, with the caveat that it's always best to seek legal counsel, but to at least be able to, flag some of the most important things to work out when you're getting together with someone and working out an arrangement or preparing to work out an arrangement, right? Before you, get on stage, when you're on the phone with a venue, as the case would be in this situation, or, at the venue, working out the details that you're going to memorialize in writing. And so when I was preparing this, I started preparing this, well, this is like a template that I use sometimes. All contracts are a little different. So this isn't like the contract, okay? It's a contract. And this can be, a contract can include all kinds of different terms. And like, you see these recording agreements that are, 38 pages long. I think a more effective contract is stripped down because a lot of that is done by design, and it's done to confuse, and it's done to pay the lawyer, et cetera, et cetera, et cetera. Some provisions, some contracts are just by their nature, because of the complexities, are going to be longer than others. But we're going to keep it simple today for today's purposes. This is for a single gig, okay? So easy peasy. And I wrote this so that it is, we're in New Orleans, obviously. I wrote this so that a musician can hand this to a venue that doesn't usually use contracts. How many of you have performed gigs where you're at a venue and they don't use a contract? How many of you have ever been stiffed? All right, enough to have this conversation, okay? So that's just one good reason to have a contract. That's just one payment, right? That's one of the terms we're going to go into. But how many of you have performed at a venue where you expected, there to be a sound guy, and the sound guy was either there, not there, or sucked? Yeah. Performed at a venue where the stage was all chanked up, and either you got injured or you could see like it could happen, right? That's happened, right? Had substandard location settings. I can't believe all of you didn't raise your hand. I mean, then you're not gigging, right? I've been to these places.
Oh, those are rhetorical. I'm sorry.
Okay. All right. Well, then that explains it. That explains it. So, okay. Okay. So I'm glad that I can do this. I didn't think I could do this before. All right. Good. Well, PDFs are different than PowerPoints. Anyway, so if you look at the services, so the musician is presenting this, and it's already, it looks like this is to entice the venue to use the contract. So it's written in a letter form, which is fine. Dear musician, even though this is your contract that you're giving to. So we're doing a little psychological engineering here, okay? But so the basic terms, what are you doing? What are your services? What are they commissioning you to do? To engage your services as a musician, okay? You can elaborate on that. You can, often is the case where it depends on the venue. It depends on, the type of venue and the duration. And festivals are different, what have you. But if you're just playing, a gig, let's just say on Frenchman Street, this is a great contract, right? So you show up, you got to be at the venue at a certain date, at a certain time. Here it clearly stipulates how many sets. So it's for 3 hours from 9 p.m. to 12 a.m. so that you can't get jacked around on when you have to show up, because that happens. Venues change their mind all the time. Well, we want you at 8 o'clock and you're still wrapping up your gig across town. So you want to be clear about what time you're supposed to be there, how many sets, because it says 3 hours, but you want 2 sets because you want a break, right? Otherwise, you're playing for 3 hours straight, and that's not very cool. I know people do it, but I've never heard anyone say that that's awesome. So this at least gives you a break. You can put in there however many sets you want. Gives the configuration. So this is, in this hypothetical, it's for a jazz trio. You don't have to put in the genre, but including a vocalist, bass, and horn. Why is that important? People get sick. In my contract, it says if someone gets sick, you can sub them out as long as the venue is okay with that. But you want to know what the configuration is. And you can change that too if the contract says you can. But in this particular agreement, if your horn player, has the flu, but, 2 out of 3 of you can make it and you got a sub, then you fulfilled the terms as long as you fulfilled the terms, right? And it's very clear. And it's easy to have that conversation. It's easy to make the phone call to the venue and be like, yo, this contract says I just need a horn player. My guy's sick. They don't want to get the flu. Can I just bring this other guy? Fine. Done. Easy, right? The term's important. Term is, it's still important in this agreement, but it's really important in other agreements, especially when it comes to licensing, and it gets more complicated then. But the term is something you need to look at, you need to pay attention to, especially in recording agreements. When you have options and complicated terms, things like that, when you have, nuances where you have to, what did one of my clients say the other day? It's like a bad breakup where you have to give notice that you're leaving and they have to accept your notice. And if they don't accept your notice in writing, then you have 15 more days to tell them, and then they have to do it again. And then it takes it's like, this is how indentured servitude happens, right? And so you have to pay attention to the term. And this just says, when you sign it and until the performance is concluded, right? Seems like common sense, but you want the term in there because you want to get paid, okay? And that's important because you're going to get paid at the conclusion of the performance, not 30 days later. And that's why the term is relevant. It's the payment. It says you're going to get a fee, and it defines the fee. And in this contract, and you can get paid a lot of different ways. You all know this. This is a little idyllic, but I have a deposit amounting to half up front and the remaining balance via check, cash, or direct deposit, Venmo, what have you, immediately following the performance and it says on site. So that means you're getting paid before you walk out. You're not waiting for that check to show up in the mail because they're not going to pay you, or they may not.
So things like that. So scenario,
Mm-hmm.
I just play a show, the contract says this, as I'm supposed to walk out with my payment. The venue manager says something like, oh, well, you know what, is it okay if we just like handle this tomorrow? Like I'm doing a bunch of other stuff, blah, blah, and you say, okay, sure. So you leave and then something else goes awry later and you don't end up getting paid at all. Does the fact that you left and kind of like you made the choice to kind of negate part of your own contract, is that gonna affect you down the line?
So
Yeah.
you're leaving and allowing them
Yeah.
more time to fulfill their obligation does not compromise your recourse in that situation. Now, if they wrote you a check for a lesser amount that's due and it wasn't clear and you didn't have anything in writing about it, you'd probably be screwed.
Yeah.
So don't take it, in some ways it's kind of counterproductive or counterintuitive rather. Don't take less money than you're supposed to, unless it's clear that, just don't do that. Just don't do that. Yeah. Just don't do it. Okay. The performance setting. Okay. This is something that is not often in your, like a standard one-off gig agreement, but I worked with a bunch of musicians during the pandemic and this wasn't the exact language they proposed. I mean, they wanted a lot more, but this was, I think, the most reasonable way I could condense some of the demands. And a lot of it was very specific to the pandemic. So I could eliminate some of it, like masks and HVAC and stuff like that, because it's just not going to, no one's going to install new updated HVAC for you all or for them, right? Don't worry about coming to my house if you want that, because it's been a long time. But this says that, and to the extent that you can get a venue to agree to this, that the location is properly permitted and that it operates with the best practices with respect to public health and safety guidelines. That's great, but hey, it's in there. Remember, this is a deterring mechanism. This is going to Scott's point earlier. Talking through this with the venue lets them know your expectations. And if you want this in writing, they're probably more likely to sweep the stage that day. Just saying. Just human condition. Providing all customary equipment required for sound amplification. Okay, so that just means, having a sound guy. I say sound guy, sound girl, sound them, whatever. Providing any additional or special equipment. And this is the way of ensuring that the sound guy is good, right? This is when, if your configuration requires, the sound to sound a certain way, this is where you stipulate what it is that you need to be able to perform your services in a way that makes you look good, makes the audience happy, turns out more money for the venue, ideally, that sort of thing. And it puts in a deadline for you all to work that out because the venue doesn't want you calling them up last minute. And that's reasonable. And it looks like you're doing the right thing. Makes them more, apt to signing this, right? Just again, some more psychological stuff. And then, this is just these are just examples of what you want. I mean, this isn't a writer, right? But, you want some water, you want some fruit, you want some snacks, you want some sandwiches, you can put whatever you want in there. I mean, most of the venues that we're talking about aren't going to go for that, or they'll sign it and I don't even know it's in there. And, you'll be lucky if you have some water, but, there are some occasions where, especially if you're on tour or something along those lines, and, you're getting off the bus and you're going into, a venue and you haven't had anything to eat, you're going to want to make sure that those that, you know, whatever provisions you need to be able to perform your services are there. Because if I go a long time without eating, I'm not drafting a contract, you know. So you want to make sure that you have everything that you need to be able to do your job, right? And that's how you frame that when you're talking with them, if that's reasonable. I'm gonna do intellectual property last. Promotion and credit. Okay, so social media, as you know, is like really important. And the way that you are marketed is important. It's a reflection of your brand. It's a reflection of your content. It's a reflection of your business. So this just says that you're going to limit your promotional material according to whatever you all plan, any written documentation that you need. And it may be that you don't. That's why it says in the event you require written documentation. In the event that, you know, whatever, in the event that your band has agreed to, or your manager, you know, has strict guidelines around how you promote yourself, you know, what the look and feel of your, you know, photographs are, that sort of thing. I'm not a social media expert. This is why I was not on the panel 3 weeks ago, but I know it's a thing. Okay. And I've reviewed a lot of contracts and it's in there now. Right. And so that's something that, you know, when you're doing a one-off performance, might not be that important, but it might be. It depends. It depends on the scale, right? So these are just things to consider. These are just issues for you to consider. And it does provide, I do think it's important that you all get credit, that musicians get credit, you know, if they are marketing, that they credit you with your performances, right? My cancellation policy is pretty great. I'm really proud of my cancellation policy. I'm assuming that the other party isn't going to read this, but this says basically, and it looks really good, but it reads very much in favor of the musician, because what it says is that I start with the clause that looks favorable to the venue. So it says you, the musician, remember you're providing this letter, but it's addressed to you. So you acknowledge that your services are unique, innovative, and personal, and that it's reasonably foreseeable that your failure to perform at the times and places required would cause us damage. Okay. Finding a suitable alternative. If you're unable to perform, you will be required to return your deposit. So that means if you're unable to perform at all, okay? And that's reasonable, you know, because that's fair, right? However, if you are able to arrange a suitable alternative configuration to which we agree, you may retain your deposit. I didn't require them to agree in writing. Get on the horn player, get on the phone, horn player has a flu, fine, all right. You get your deposit, okay? So only do you have to give your deposit up if the whole band can't perform. Best line is 7B, which says that should the event be canceled due to our fault, we agree to pay you the entirety of the fee. So you keep your deposit and that gives you recourse to go after them for the remaining part of the fee, okay? If you have to do that, you have to either hire someone to do it or go after them but you do have recourse. And that means the night opens up and you've been paid and you get your money and you can go do another gig and double dip. So I like that clause. That's totally reasonable. But the second part is really very much tilts in favor of the musician, as it should. The force majeure clauses, force majeure is, you all probably already know this, you know, if a hurricane happens or if there's a pandemic, you know, we've had all the force majeure incidents happen. If there's a riot, I mean, there's war, all right, all of the above, check. If that happens, what I have in here, and this is where I'm kind of banking on them not reading, is that in the event of a force majeure that you get to keep your deposit. Because it's not their fault if there's a hurricane. But you know what? If there's a hurricane and you got to leave and your performance was a week later and, you know, still can't get back, that's not your fault either. So just to make it simple and clear and, you know, you already have your deposit. So you don't have to go after them for it. This, you know, contract is written so that you've already acquired your deposit. So it just means you don't have to pay them back. A lot of people aren't going to sign that. A lot of people aren't going to bargain for that, but if they don't read it, they will. And that's not your fault.
If it were an event, like a festival event or something, and does happen to be a weather event or whatever, and the musician's already there, and the event gets canceled.
Mhm.
It's not technically the venue's fault per se.
No, that's
But they
a
can
force.
still get paid for the whole day if they're there and you're canceled out of weather, right?
That
Even
could-
Insurance can cover them.
Well, that depends, bingo, insurance on the context. So some places will have insurance and some won't. So again, what I said earlier is this is kind of written for a one-off, like your standard club owner. Not your jazz festival type gig where there's insurance for each, act or for each day, right? This is the idea of this, of what we're looking at right here is to do what you just did, is to flag these issues so that it gets you to thinking about them and to think about all the other scenarios that can arise. So yes, I mean, that's something that, in my more extensive contracts, we go into postponement versus cancellation. And we go into, whether it's, postponement due to your fault or my fault, or, when the force majeure clause gets extended a lot. This is the keep it simple, stupid version of that. But yes, you can include and should include, depending on the circumstances, all of those provisos. And I would certainly make sure that, like I said, depending on the scale, that you keep your entire fee. This is assuming you haven't, this is assuming you're working with a venue that is not accustomed to, that is accustomed to being required to pay, like, to making them pay you, right? Because that happens a lot, okay? This contract was written in that circumstance. So this is not your Quint Davis AEG insurance, plaid, contract or situation where you know that they have the money, right? Does that make sense? Okay. Yeah, I would make sure in that event that you get paid no matter what, but they have a team to do that. This is like some guy standing in the wings that, that is having your bouncer go up and pay cash or check or whatever. I mean, it doesn't have to be like that, but there's a big difference. There's a broad spectrum of scenarios in which you perform.
Well, we saw this through the pandemic, right, with all these new regulations and stuff, so a lot of the issues that some of our arenas, I'm not gonna say which ones necessarily.
Yeah, no, I know.
But what the issue was, the onus was put on the city.
Oh, that's a whole other.
Requirements
Mhm.
and stuff,
Right.
Well, the city is requiring this, it's not us.
Yeah.
But if that's a requirement, like for you to build it, if you to work or go to a show or something like that, then there was, a little bit greater.
That was a layered situation. Yeah, that was performing under a force majeure, which made it, exponentially more complicated. And I understand what you're saying. And that may happen again, but let's hope not. Let's hope we don't have to worry about bird flu and stuff like that. But, who knows? Okay, don't go to the news today. Don't do that. Notices. It's important for everyone to know where to contact each other, and it's okay to do it via email. And I just have this saying that as long as you don't get a response, it's an auto response, or they don't get an auto response from you saying, I didn't get this because I'm on vacation, then it's considered received. That way you don't have to prove anything. You sent it. That's on them to keep up with whether they're checking their email or not. We're all adults here. This is written for like the situation where the club owner is the bouncer and the bartender and the check writer and the custodian and all of the above, super simple. But all of these clauses can be expanded upon, and there's other, again, like I said, and I hate to keep repeating myself, but there are lots of other provisions you can include too. Finally, you don't have to have the governing law provision, but you want to know where the contract is bound. And if you're doing this, if you're contracting with someone in Louisiana, you're in Louisiana and they're in Louisiana, all right, the Louisiana law is going to bind it pretty much, no matter what, with exception. But, there are cases where that's different. And this is the difference between, let's just say, you this was a very big scale event and you were promised a lot of money and it's worth suing in court, you want to make sure you're going in your backyard and not theirs. Because you want to hire a local lawyer and you don't want to have to pay for a flight to go to Missouri. I said Missouri because the last venue contract I looked at was literally Missouri yesterday. And I was like, Missouri, that's the first. But yeah, you don't want to have to do that. So you want to make sure that, you're the one who's not inconvenienced if you do have the unpleasant experience of being forced to sue someone in a court of law. So these are just your standard, like, make sure these line items are covered in all of your agreements and expanded upon to the extent needed, the extent likely needed, to your point. Are there questions about this? Oh, shit, sorry. I forgot the most important part. I said I was going to go back and here I am. Intellectual property, okay? So this isn't a record deal. This isn't a publishing deal. But how many of you have ever gigged where you're being filmed? Like everyone's doing it now, right? Whether they're using it on social media or, whether they want to put out a compilation with, the best of the bands that have performed there live or, what have you. You want to make sure, and what this stipulates is that if you agree to them filming you or making sound recordings, that, first of all, you have to approve. If you do approve, you authorize their use of your name, image, and likeness so that they have to credit you, okay? And we call whatever version of whatever they're doing, whether they're recording just a sound recording or an audio visual recording, a video, we're calling those ancillary works because we want to distinguish that from your underlying work, your compositions, because we want to make sure that they understand that you retain 100% of your interest in your copyright to your song. That if just because you agree to allow someone to record you or to film you doesn't mean you're giving up your interest in what you're performing if you own it, okay? So this ensures that you retain 100%, for the sake of clarity, of your copyright and that you're not assigning it by allowing them to film you and or record you. And ideally, if the situation arises, then you do expand upon this and you stipulate, how they can use their video of you, how they can use the recordings of you. Because, if you're under a record contract or another agreement, you may not be able to authorize those usages. It depends on what other agreements that you have. So if you have an agreement with, a record label that says, you can't allow anyone else to use any other sound recordings of the song we produced for you. I mean, you can perform it, obviously, please do. We'll sell more records that way, but don't allow anyone to record you and release it, because if you do, you're violating our contract. So if you do allow that and you're not if you do allow someone to record you and to use that recording and it violates your existing arrangements, then you're in trouble. So you have to be aware of that. So the reason why I put this in here is to just, again, like to flag that and to make you aware of that and to let you know that, since this is custom these days, since everyone is filming, it's something you need to make sure is covered because you want to maintain your rights and you want to make sure that you don't violate your arrangements with third parties, with anyone else, and that you don't end up getting sued or, having your royalties put into trust until you work out the arrangement, with whomever is paying you your royalties, that sort of thing. So that's why I put this in there, but it would probably be more extensive depending on the scale of the of the arrangement. Does that make sense? Sorry, I know that was a lot of repeating. This is not a one size fits all situation. Go ahead.
Can you scroll to the top for the first, the number one?
Yes, I can. I hope, actually, that might be the hardest thing I have to do. I can, and I'm doing it right now. There you go. Any other questions? We are 2 minutes from 4, but I'm happy to answer questions.
Get a copy of that.
No, you can get a copy of, and I hate saying no. You can get a copy of the other slides, of the workshop slides, but not of the agreement, because I can't just give you an agreement without talking to you individually one-on-one, because I got to know that you know how to use it. This isn't enough for that. This is educational. This isn't legal counsel.
Have we figured out the whole AI situation?
No, no one's figured that out. Is that really what you're going to ask me last question? Have we figured